Are you 60 or older, afraid you can't afford to keep your home? You might not have to. I read the law itself and the record from Congress. It's real, and it's already in effect. Here are the 5 wins: home repairs, cheaper homes, renter help, small mortgages, and a Wall Street limit. Let's go. My name is Eric. I'm going to walk you through all 5 of these wins in order, show you the exact part of the new federal housing law behind each one, and end with a 1-page action plan so you can start making the right phone calls this week. Win 1 is money to fix up the home you already live in. Most people over 60 tell every survey the same thing. They don't want to move. They want to stay in the house they already own, the one that's paid off, the one with the door frame where they marked the grandkids' heights. But staying there safely is a different question than owning it. Picture the bathroom that's turned dangerous, a slick tub with no grab bars, a toilet that's too low, a front step with no railing. Picture a roof that's had a slow leak for 2 winters, caught in a bucket. Somewhere between $8,000 and $15,000 in repairs stands between an older homeowner and staying put with dignity. And on a fixed Social Security check, that number might as well be $1 million. And the stakes behind that repair bill are bigger than the bill itself. When a home becomes unsafe, the next step is often an assisted living facility that can run $4,000 or $5,000 a month, which drains a lifetime of savings in a couple of years. A few $1,000s of repairs that let someone stay in a paid-off house is not just cheaper, it is the difference between staying independent and a bill that never stops. That gap is exactly what this piece of the law goes after. The new federal housing law authorizes a whole home repairs program, run through the Department of Housing and Urban Development, and it is one of the only parts of this entire law that names older adults directly. Here is how it works. The Housing Department funds local organizations, and those organizations provide grants to eligible homeowners and forgivable loans to eligible landlords to fix the things that make a home unsafe or unaffordable to live in. The covered work is spelled out in 3 buckets. First, accessibility for older adults and people with disabilities, which the law lists as grab bars and handrails, ramp additions, and widening doorways and hallways for a walker or a wheelchair. Second, health and safety hazards, the habitability problems that turn into emergencies. And third, energy and water efficiency and weatherization, the insulation and sealing that cut the energy bill every month afterward. The grants go to the homeowner, and the forgivable loans go to landlords. So a fixed-income owner is not asked to take on new debt just to make the house safe. And the covered work is aimed squarely at the repairs that most often force an older person out of a home they own free and clear. Let me show you what that looks like with real numbers. Picture a widow, 78 years old, in a paid-off house, living on a Social Security check of about $1,800 a month. Her bathroom is unsafe and her roof is failing, and a contractor quotes her $12,000 for both. On her budget, that quote means she simply lives with the danger, or she borrows against the house she spent 30 years paying off. Now her state's whole home repairs program is open. She calls, she qualifies on income, and the grant covers the grab bars, the ramp, and the widened doorway, while the structural roof work comes through the forgivable loan side of the program. Her out-of-pocket cost lands near zero, and the $12,000 never leaves a bank account she doesn't have. And the weatherization piece keeps paying her back. When the program seals the drafts around her old windows and adds insulation in the attic, her heating bill drops by something like $60 or $70 a month through the winter. So the same visit that made her home safe also made it cheaper to run for every year she stays. That second saving is the part most people never expect, and it sits in the same program as the grab bars and the ramp. Here's the catch. This is a pilot, and it phases in region by region rather than switching on everywhere at once. Some of the help is a straight grant, and some is a forgivable loan, which is not a normal loan. A forgivable loan is a debt that disappears if you meet the program's conditions, usually staying in the home for a set number of years, so you are not expected to pay it back out of pocket the way you would a mortgage. The program is authorized to run for several years, through the fall of 2031, but availability in your zip code depends on your state and local agencies standing it up. So the move is to call and ask when it opens where you live. This is written into the new law itself, in the section that creates the whole home repairs program. Win 2 is a wave of cheaper, smaller homes to move into. This is the trap a lot of retirees are living in right now. You've got a 4-bedroom house, the kids left 15 years ago, and you are done heating rooms you never walk into and mowing a lawn you don't need. You want something smaller, cheaper to run, closer to your doctors, ideally with a little equity left over from the sale. But when you go looking, there is nothing smaller in your price range in your area, so you stay put in a house that no longer fits your life because there is nowhere sensible to land. This law leans hard on the reason that smaller housing barely gets built. It loosens the rules. First, it changes the decades-old requirement that a manufactured home sit on a permanent steel chassis. The old rule existed mainly to keep these homes towable, even though almost nobody ever moves one once it's placed, and it added cost for no real benefit. Striking it lets manufactured and modular homes be built more like ordinary houses, and those homes are often dramatically cheaper to build than a stick-built house on site. Second, the law opens a path to convert vacant office buildings into housing, with the change in building size limited to no more than 20%, which turns empty downtown space into places to live. Third, it directs the housing department to publish zoning best practices for local governments, aimed squarely at the codes that make it illegal to build anything but one large single-family home per lot, and it specifically calls for ending bans on accessory dwelling units and on duplexes, triplexes, and quadplexes. Let me make that concrete with real numbers. Picture a couple in their 70s in that 4-bedroom house, worth, say, $300,000 and paid off. An accessory dwelling unit is a small, separate home on the same lot, sometimes called an in-law suite. Under these changes, they could build one, move into the smaller unit themselves, and rent the main house out for something like $1,400 a month, which on its own can cover most of what they need beyond Social Security. Or they could sell the big house entirely and buy a new modular home for around $90,000, when a conventionally built house of similar size in the same town might run closer to $200,000. That gap, roughly $100,000, is money that stays in their retirement accounts instead of going into lumber and labor. Either way, the smaller, cheaper footprint they could never find before starts to exist. Here's the catch. None of this puts a house on the market next month. Zoning reform and new construction take years to show up as homes you can walk into and buy. The chassis change and the office conversions lower the cost and clear the path, but the inventory arrives gradually, not overnight. So if downsizing is anywhere on your horizon in the next 1 to 5 years, the time to start learning your local options and talking to a housing counselor is now, not the week you list the house. This is in the law's manufactured housing and zoning sections. Win 3 is a new, direct line for renters stuck with a giant corporate landlord. If you rent, and at some point your building or your rental house got scooped up by a big investment firm, you already know the drill. Your maintenance requests vanish into a call center. New fees appear that were never in your lease, and there is no actual person to hold accountable, just a portfolio of thousands of units behind a corporate name and a payment portal. That specific problem, the faceless institutional landlord, is what this piece of the law addresses. The new law requires the Department of Housing and Urban Development, within 180 days of the law taking effect, to establish a renter outreach resource. In plain terms, that is a toll-free telephone number and a public website designed specifically to help renters of homes owned by a large institutional investor. I want to be precise about what it is and what it is not, because other people are already overselling it. It is an outreach and complaint routing channel, a place to flag disputes and possible violations to the federal government. It is not a courtroom, and it does not come with new legal powers of its own. But for someone whose landlord is an investment fund instead of a person they can call, having any federal point of contact at all is genuinely new. It did not exist before this law. Let me walk one scenario through. Picture a retiree renting a single-family home that was bought by a company that owns thousands of houses across several states. The heat goes out in November. The repair request disappears into a call center, and a new monthly fee of $85 shows up on the payment portal with no explanation and nobody to question about it. Over a year, that one unexplained fee alone pulls more than $1,000 out of a fixed retirement check. Under this law, she has a federal number and website built for exactly her situation, to report the problem and create a record of it. Now the part most renters miss. This resource routes and documents. It does not, by itself, force a repair or reverse a fee. Your strongest day-to-day protection as a renter still comes from your own state and local tenant laws, and those vary a great deal from one state to the next. So use the new federal line to report and to build a paper trail, but pair it with the real muscle, which is learning your state's specific tenant rights and calling a local legal aid office, many of which help at no charge. Keep every text, every email, and every dated photo of the problem, because a paper trail is what turns a complaint into leverage. And if a fee or a notice looks illegal under your state's law, a legal aid attorney can often stop it far faster than any federal complaint line can, at no cost to you. This is in the laws section dealing with large institutional investors. Before I show you the last two wins, which carry the biggest numbers of the day, one thing needs saying plainly. This video is for educational purposes only and is not tax, legal, or financial advice. Talk to a qualified professional before making any decision about your specific situation. If what I'm showing you is useful, hit the subscribe button and the notification bell. That's what tells YouTube to push this kind of plain English retirement walkthrough to more of the retirees who need it. And if you want the one-page checklist version of this episode, with every program, every phone number, and every deadline I mentioned today on one printable sheet, the link in the description has the new housing law checklist waiting for you. Win 4 is a mortgage finally built for a smaller, cheaper home. Here is a problem almost nobody talks about, and it quietly locks people out of homes they can genuinely afford. Say you want to buy a modest house in a lower-cost part of the country, something around $90,000, which is a completely realistic price in plenty of towns. You have savings for a down payment. On paper, you can easily afford it. But lenders often will not touch a mortgage that small because the fees and interest a $90,000 loan generates aren't worth their paperwork and their time. So you get priced out of housing you could comfortably pay for, purely because the financing system was never built for the smaller end. This law goes straight at that. It directs the Federal Housing Agency to run a pilot program to widen access to what it calls small-dollar mortgages, and it defines that term plainly. A small-dollar mortgage is a home loan with an original balance of $100,000 or less, the exact size of loan the market keeps refusing to write. On top of the loan itself, the pilot can provide direct grants to those buyers to cover the costs that usually sink a small purchase, and the law names 4 of them specifically: down payments, closing costs, appraisals, and title insurance. Let me put numbers on it. Picture a retiree who has saved a modest down payment and finds a solid little house for $95,000 in an affordable area. Today, she calls 3 lenders, and all 3 pass because the loan is too small to be worth their while. So she keeps renting and keeps paying a landlord every month with nothing to show for it. Under this pilot, a participating lender originates that $95,000 loan, and a direct grant covers her closing costs and the appraisal, the few $1,000s that would otherwise have stopped her at the finish line. The difference for her is the difference between renting for the rest of her life and owning a small home she can pay off. Put the yearly math next to it. If she keeps renting at, say, $1,100 a month, that is more than $13,000 a year leaving her hands forever, with no equity at the end of it. Under the pilot, that same money goes toward a loan that one day ends on a house she owns outright, and the grant covers the $3,000 or $4,000 in closing costs and appraisal fees that would otherwise have been the wall she could not climb. Here's the catch. This is a pilot, which means it depends on lenders in your area choosing to take part. It will not be available everywhere on day 1, and a program that no lender near you has joined yet cannot help you yet. So before you get your hopes up on a specific house, ask a housing counselor whether the small dollar mortgage pilot is live with any lender in your market. This is in the law's small dollar mortgage section. Win 5 is the one I did not expect Congress to touch, and it is where the biggest number in this whole video lives. It's a hard limit on Wall Street buying up single-family houses. You have watched this happen over the last several years. Big investment firms buying single-family homes by the thousands, renting them back out, and quietly pulling that inventory away from regular buyers. So a family trying to buy their first home keeps getting outbid by a corporation with unlimited cash. Most people assumed nobody in Washington would ever put a leash on that. This law does. Here is the actual rule. Any company that has investment control of 350 or more single-family homes, alone or working in construct with other entities, generally may not purchase any more single-family homes. And this is the part that surprised me when I read it. The penalty has real teeth. A violation carries a civil penalty of up to $1 million per home, or 3 times the purchase price of the property, whichever is larger. $1 million per house. That restriction takes effect 180 days after the law, which lands in early 2027, and it stays on the books for 15 years. There are carve-outs, the main ones being newly built homes in a build-to-rent program and communities built for people 55 and older. Let me connect that to your life directly. Think of the family member you are rooting for to finally buy a place of their own, bidding against a firm that already owns thousands of houses. Once that firm crosses the 350 home line, it is barred from buying the house your grandson wants, or it risks $1 million penalty on that single purchase. That changes who is standing across the table at the closing. Think about what that firm was doing to the math before. When a corporation with unlimited cash bids on a modest starter home, it can pay above the asking price, waive the inspection, and close in days. And an ordinary family with a normal mortgage cannot compete on those terms. Take that firm out of the bidding once it crosses 350 homes, and the house your grandson wants goes back to being a contest between families, not a contest against Wall Street. Here's the catch, and I'll be honest about the limits. 180 days is a long runway, and a firm with resources can keep buying right up to the deadline. The law does not force any company to sell the homes it already owns. And because the 350 home threshold is measured per entity, there is a real risk that big investors split themselves into smaller companies to stay under the line. something Congress may have to come back and tighten. So this slows the problem. It does not reverse it overnight. And anyone who promises you that home prices will drop the week this takes effect is overselling it. What it does is stop the worst of the corporate buying at the top and buy time for the supply changes in the earlier wins to catch up. But paired with the supply wins earlier in this video, it is a genuine, if gradual, tilt back toward individual buyers, including whichever member of your family you want to see own a home. This is in the laws section on large institutional investors, and the $1 million penalty is written right into it. Here is your one-page action plan. 1. Call the Eldercare Locator at 1-800-677-1116 and ask your local area agency on aging when the whole home repairs program opens in your zip code. 2. Call a free housing counselor approved by the Department of Housing and Urban Development at 1-800-569-4287, because one call can tell you which of these 5 wins applies to you. 3. If you are thinking about downsizing, ask that same counselor whether the small dollar mortgage pilot is live with any lender near you. 4. If you rent from a large corporate landlord, save the new Federal Renter Resources number when it opens and keep a written record of every repair request and every fee. 5. If firms are buying up homes in your area, know that the 350 home limit exists and takes effect in early 2027, and say so at your next town meeting. Same law, 2 retirees. The first one never makes a single phone call, and every one of these 5 wins passes right over the top of them. The repair grant, the cheaper home, the renter line, the small mortgage, and the Wall Street limit. All real, all sitting there unclaimed. The second one makes 2 phone calls this week and finds out in one afternoon exactly which of the 5 belong to them. The law is word for word the same for both people. The phone call is the entire difference. Next, I'm walking through the 5 state benefits that disabled veterans over 60 are leaving on the table. The property tax that can go to 0, the registration fee that gets waived, and the emergency grant almost nobody applies for in time. Before that, tell me in the comments, do you own your home or do you rent? Because the next housing video splits the advice by exactly that. I read every single comment, and the most common questions become future videos. I will see you in the next.